And the CGI has announced that Article 370 is a temporary provision and has announced that statehood shall be restored in J&K soon. During his concluding statements, he emphasized that J&K does not retain any element of sovereignty after instrument of accession was signed. No internal sovereignty for Jammu and Kashmir. He further spoke on how... And for more on this, we're now being joined by our correspondent, Devanshu, who is right now standing at the Supreme Court of India. Hi, Devanshu. The CJ has announced that Article 370 is a temporary provision. What's the latest?
Well, Rahesha, the five bench led by Chief Justice D.Y. Chandrachud has delivered its verdict. As per the latest update from the Supreme Court, we can get to know that the court has said the Article 370 is temporarily, and the President has the right to abrogate it. The Supreme Court has also directed the Election Commission that it needs to hold election in the state of Jammu and Kashmir in the coming months. It has also mentioned that there is no independent sovereignty for Jammu and Kashmir, since at the time of independence there were three options given to the state of Jammu and Kashmir, whether to emerge as an independent state, or to merge with Pakistan, or to come and merge with India. At that time they chose to be in India, so there is no clarity whether that it should come as an independent state, but whatever the article states in 370, they need to follow it. As per the latest, Rahesha, the court has also directed the Supreme Court hearing that the Article 370 is temporarily, and the President has the right to abrogate it, and following which it also mentioned that challenging President's rule is not constitutional, so it cannot be challenged back and forth. Back to you.
Right, Devanshu, shed some more light on what the Supreme Court said about the special status of Jammu and Kashmir.
Well, regarding the special status, Rahesha, as I mentioned earlier, it does not hold any special status right after 370, because the Supreme Court clearly indicated that soon after the independence, the state was given three options: either to merge with Pakistan, or come as an independent state, or come with India. At that time, they chose to be with India. So there is no story. There is no story regarding the special status. Whatever is decided by the presidential rule, it needs to follow that.
Right, Devanshu, also talk to us about what were the challenges that the petitioners had put forward.
Well, the challenges were basically regarding whether it's constitutional to abrogate the 370, and at the same time the petitioners had also mentioned that had also challenged the center's decision of reorganization of the state, reorganization of act of the state, like they bifurcated the state into two union territories, that is Jammu and Kashmir and Ladakh. So they had also challenged that. But as per the latest update from the Supreme Court, Rahesha, it can be seen that the presidential rule is valid, and there is no scope of challenging it constitutionally and legally.
Right, Devanshu, the CJI also spoke on how there is a clear absence in the constitution of Jammu and Kashmir to the reference of sovereignty.
Yes, he spoke about a lot of facts. I mean, the verdict is still going on, but the main highlights have come out of the verdict. Basically, he states that Article 370 is temporary, and President holds the right to abrogate it. This was the main challenge, which was challenged by the petitioners, that whether it's constitutional to abrogate the Article 370, and at the same time bifurcating the state into two.
Right now, we're also being joined on this ruling verdict. We're joined by Kuldeep Khoda, former DGP and former Intelligence Chief, J&K Police, joining us live from Jammu. Welcome to the broadcast, sir. The CGI has said that Article 370 is a temporary provision. Your first response to it?
You know, the CGI mentioned very clearly that the plain reading of the article says it is temporary. Besides, right from 1949, when the then Yuvraj issued a proclamation which clearly started the process of further integration of Jammu and Kashmir with the rest of the country. And this was an ongoing process. The modifications through various government orders and through various proclamations had been going on continuously. And the August 2019 order was culmination of that integration when it has been completed. So never in the past any such issues were raised, and they were always accepted. And the Chief Justice very rightly said that at this the J&K state did not enjoy any kind of different sovereignty other than the type of which other states of the Union of India enjoy. So he has read out the judgment very systematically,
Yes.
based on the Constitution of India, and he clearly stated that the Constitution of J&K was subservient to the Constitution of India. And regarding the consent of the Constituent Assembly, which was very highlighted by those challenging this order, that the Constituent Assembly agreement is required for any such change in Article 370. The unanimous judgment clearly mentioned that once the Constituent Assembly ceased to exist, the question of any powers of such agreement of Constituent Assembly were also extinguished by that. So the only thing which the CGI mentioned is that the change in the definition which was made, that the Parliament, that the Constituent Assembly is to be converted, should be read as Legislative Assembly. That is not correct. But at the same time, the judgment mentions that the President has the powers and the Parliament has the powers to amend anything pertaining to any state, and it is not restricted to. It was not restricted to making of laws only pertaining to J&K, because the special status granted the power of state consent also for enacting any law. The Parliament said that the Supreme Court mentioned that Parliament has its own powers, wide-ranging powers, to enact anything beyond law also.
Yes, sir.
It can amend anything beyond the law also. So in a way, it is clearly mentioned that the sovereignty of J&K, which was proclaimed to be a special type of sovereignty, the Supreme Court mentioned that there was no special kind of sovereignty, and the Parliament section and the President's order are not in violation, and unless the opposite party tries to establish that it was a mala fide order, it's a valid exercise of powers.
As in top cop and administrator who has also served in Jammu and Kashmir, do you think this was required? The uncertainty about J&K because of this special provision was leading to all sorts of problems, all sorts of uncertainties. It was, first of all, making the people of the state think on whether we are actually part of India the way other states are there. That has been clarified. Now there will be no debate on this issue, because there has been a constant rant in the past by various political parties that J&K special status should be further amplified into granting some sort of autonomy to the state. Now this was a sort of struggle going on. On one hand, those who were inclined to granting more and more powers to state were pulling the string in one direction, whereas those who wanted J&K to be part of India like any other state, they were pulling the thing in other direction. This struggle was going on. This was putting the people of state in uncertainty, and uncertainty is never good for any place, whether it is development, whether it is law and order, whether it is any sort of progress. The uncertainty is over. The Supreme Court has clarified this thing in its entirety.
and with proper arguments and the law of the land, and also considering the Constitution of India, the judgment is very clear, and the division of the state by carving out Union Territory of Ladakh has also been cleared by the Supreme Court judgment. The only thing is about that whether J&K could be converted from a state into a Union Territory, that Supreme Court has not deliberated upon. That is because they said that the Solicitor General has given an clarification on this in the court, that it was a temporary measure and statehood will be restored. And the Supreme Court has mentioned that statehood should be restored as early as the center considers it fit, as soon as it is possible.
Yes, absolutely.
And about the elections, the report has also laid down the last date of 30th September 2024, that elections should be held. And Union Carving of Union Territory of Ladakh separately, that has been upheld.
Right, you speak of our uncertainty is over at the moment. Talk to us about the implications of the verdict.
Say again?
I'm saying you speak of our uncertainty is over at the moment. Talk to us about the implications of the verdict.
Absolutely, the uncertainty is over. The elements which were the separatist elements have also got a clear message. Now it will be difficult for them to operate, and for Pakistan also, and for some of the international voices, like from Turkey, the president of Turkey, and others who were trying to question all this, that this was not a legal exercise. Their voices have been silenced, and because this judgment is based on law, based on the Constitution of India, and nobody not only in India but elsewhere also can question now this.
Right. Also, the CGI said that there is a clear absence in the constitution of Jammu and Kashmir in the reference of sovereignty. Help us understand this statement by the CGI.
Absolutely. Supreme Court has very clearly mentioned right from beginning. It is clear that J&K did not enjoy any kind of different sovereignty other than what is prevalent in other states. And whatever powers other states have, J&K has no, except for the lawmaking powers, special powers, which were granted under 370, which cannot be considered as some sort of sovereignty. It was only an administrative or a legal exercise, which was whereas a special provision was made for J&K under Article 370. And the process of integration was always happening through various acts of state assembly and parliament also. And the notification of August 5, 2019 was the culmination of that process of integration. And the instrument of accession, when it was modified by the proclamation of November 1949, that led the instrument of accession also subservient to that proclamation. And through that proclamation, the integration of J&K with the rest of India in its complete sense was also clarified, that it is part of India in every respect.
Another point to the statement you made, that India's CGI has also asked J&K that does not hold any integral sovereignty after accession to India in October 1947.
You know, one point which was there that which was being constantly mentioned by those parties who had challenged this government proclamation was that the Constituent Assembly nod is required, because that was mentioned in the Constitution of J&K, that any amendment to the Article 370 will require that nod of the Constituent Assembly, and that nod was not obtained. And what Government of India had done, that they revised the definition of the Constituent Assembly as State Assembly, and because of the President's rule in J&K, the powers of the State Assembly were restored in Parliament, and Parliament then passed the order. The Supreme Court clearly mentioned that though the definition could not be changed when the government did not have the powers to change to use a different method by changing the definition of Constituent Assembly and saying that the Legislative Assembly will be the Constituent Assembly because the Constituent Assembly has ceased to exist. The Supreme Court clearly mentioned that that the powers of the Constituent Assembly to recommend had ceased to exist because of the Constituent Assembly being dissolved way back in 1957. So those recommendation power had ceased to exist. So there was no need to get the consent of Constituent Assembly since it was not existing. So the entire exercise of the government of converting through change in definitions to convert the Constituent Assembly into Legislative Assembly, and the Parliament exercising the powers of the Legislative Assembly because it was under President's rule, that exercise was not properly required.